Hello students, welcome to AKS. In this video, we will discuss about the Union Executive. So the provisions related to Union Executive are made in Part 5 of the Constitution of India. Okay, so let us get into the details of the same. Article 52. Article 52 of the Constitution declares that there shall be a President of India. So within Union Executive, we are discussing about the President of India under Part 5 of the Constitution. Article 52 declares that there shall be a President of India. Article 53 tells about his functions, broad functions. The President of India will be the Supreme Commander of the Armed Forces. Supreme Commander of the Armed Forces of the Indian Union. It also says that the executive power of the Indian Union will be vested with the President of India, and this executive power will be exercised directly or indirectly through the officers subordinate to the President of India. What is the significance of Article 53? The officers subordinate to the President of India is the Council of Ministers. So India provides for a parliamentary government where the real powers are exercised by the Council of Ministers headed by the Prime Minister. Officers subordinate to the President of India will also include the civil servants. This provision is provided to enable the President to act on his own in certain circumstances, which means the President can act in his discretion only in certain circumstances. Having discussed about this, let us discuss about Article 54 of the Constitution. It defines the Electoral College. It defines the Electoral College to elect the President of India. The Electoral College of the President of India consists of the elected members, not nominated members. Please note that nominated members are excluded. It is only the elected members of both houses of the parliament, that is the Lok Sabha and Rajya Sabha, and number two, elected members of the state legislatures, that is state assemblies. So the Electoral College for electing the President of India consists of elected members of the parliament and elected members of the state assemblies. Who are excluded from this Electoral College? Nominated members of the Lok Sabha are excluded. Usually, who are the nominated members of the Lok Sabha? You have two Anglo-Indians to be nominated to the Lok Sabha. Those members are excluded from the Electoral College. Number two, nominated members of the Rajya Sabha. You have 12 members who are nominated by the President of India to the Rajya Sabha. These 12 members having special knowledge in social services. So these members are also excluded. Number three, the legislative councils of the states are also excluded from the Electoral College to elect the President of India. The Presidential and Vice Presidential Election Act 1952 was amended in the year 1992 under the 78th Constitutional Amendment Act. By this, the legislative assemblies of Delhi and Puducherry will also be part of the Electoral College. So we have discussed about the Electoral College to elect the President of India. Now let us discuss about Article 55. Article 55 defines how the President of India is going to be elected. What is the method of election of the President of India? What is the method of election of the President of India? The President will be indirectly elected by an Electoral College. Indirectly elected. So the President is indirectly elected by a system of proportional representation by a single transferable vote to the secret ballot. So the President of India is indirectly elected by a system of proportional representation by a single transferable vote through a secret ballot. The formula for equalizing the value of vote of all the MLAs with the value of vote of all MPs is also mentioned within the Article 55 itself. So the value of vote of one MLA is equal to the total population of the state by the total elected MLAs of the state assembly into 1 by 1000. The value of vote of one MP that votes for the president is equal to value of vote of all elected MLAs by the total elected MPs of both the houses of the parliament. So this is how the valuation of the votes of the MLAs and MPs are done for the presidential election. So a contestant has to get a minimum number of votes called the quota to be declared as the President of India. The quota is the total valid votes cast in the election for all the candidates by 2. This whole plus 1 is the quota that a candidate needs to get elected as the President of India. The President of India can be removed by impeachment only. That is, the President of India is the only constitutional office he is the only constitutional office that can be impeached. The judges of the Supreme Court and High Court are also removed from their office by adopting more or less the same procedure, but it is not called as impeachment. It is called as removal from the office. So when you are talking about impeachment, it is only the impeachment of the President of India. Now let us move to Article 56. Article 56 states that the President of India will have a 5-year term of office. Okay, from the date of his entry to the office, 5-year term from the date of his entry to the office, that is not from the day of election. It is not when the president is elected. From that period, the 5-year period is considered. It is from the date he has entered his office, from that day. That means from the date he takes the oath, from that day, he is considered as a president of India for 5 years. The president, when he wants to resign, he will address such resignation to the vice president of India. Having discussed that, let us move to Article 57. Article 57 says that the President of India is eligible to seek re-election as many times that he wants to. Just now, a while ago, we discussed about Article 55. Article 55, it said that the President can be impeached, right? We have discussed that the President can be impeached. But on what grounds can the President be impeached? The President can be impeached on his failure to protect, preserve, and defend the Constitution of India. That is the primary role of the President of India. The primary role of the President of India is to protect, preserve, and defend the Constitution of India. The judges and the Chief Justices of the High Court and the Supreme Court are removed from the office on the grounds of malafide activities. Impeachment of the President. Impeachment as a procedure is unique to the President of India, as he is the highest constitutional office and is vested with the responsibility to protect, preserve, and defend the Constitution of India. Now let us discuss Article 58 of the Constitution. Article 58 provides for the qualifications for a person to be elected as a president. Qualification for a person to be eligible to occupy the office of the President of India. What are the qualifications? Such person should primarily be a citizen of India. That is, non-citizens or aliens cannot be part of the electoral process, or they cannot be elected to the office of the President of India. That person shall have a minimum age of 35 years, and such a person should be eligible to become an elected member of the Lok Sabha. That is, he should be registered as a voter in any of the Lok Sabha constituency in India. Also, the President of India cannot be a member of the Parliament and the state legislature when he is in office. A contestant for the President of India can be an MP or MLA or a minister or the President or a Vice President or the Governor. That is, before he takes up the oath as a president, he should resign or give up the membership of the Parliament or any other post that he's holding, like that of the President or the VP or the government. The contestant should not occupy any office of profit under the government of India, state, or any other local authority or public office. The president, the vice president, the governor, the ministers are not debarred from contesting the presidential office. They can contest. The nomination of the candidate must be subscribed by 50 electors as proposers and 50 electors as seconders. The candidate has to also give a deposit to the RBI. So this is the procedure, all the qualifications that a candidate should have before he contests election to the office of the president. Then let us discuss about Article 59 of the Constitution. It deals with the conditions of the presidential's office. Conditions of presidential office. That is, the president shall not be a member of the parliament of the state legislature or a minister nor a governor or a VP. That we already discussed. He should not hold any other office of profit. The President of India will not hold any other office of profit. The President will be entitled to an official residence without rent, and the Parliament will pass a law to determine the salary and allowance of the President of India. As long as the Parliament has not made a law determining the salary and allowance of the President of India, his salary and allowance will be specified in Schedule 2, second schedule of the Constitution. Now let us discuss Article 60 of the Constitution. Article 60 defines the oath of office of the President of India. The oath of office of the President of India is administered by the Chief Justice of India. Please note this. This could be an important prelims question. Who administers the oath of office of the President of India? It is the Chief Justice of India. Okay. It is the duty of the President to protect, preserve, and defend the Constitution. Article 61 lays down the procedure for impeachment. Article 61 lays down the procedure for impeachment of the President of India. That is, the initiative to impeach the President can be initiated by either house of the Parliament. The initiation is taken by the form of a resolution which contains the charge of the impeachment of the President of India. That is, 1/4 of the total strength of the Lok Sabha should give the signed resolution to the Speaker, who should summon the House in 14 days of notice. Within 14 days of notice, that is, the Speaker or the Chairman of the Lok Sabha or the Rajya Sabha shall summon the House within 14 days. When 1/4 of the total strength of the Lok Sabha or Rajya Sabha gives such resolution, this resolution can be adopted if a majority of the 2/3 of the total strength of the House, that is a special majority. The President of India is impeached by a special majority. The President of India is impeached by a special majority. He is impeached by a special majority wherein 2/3 of the total strength. This is called a special absolute majority. 2/3 of the total strength of the House votes for the impeachment resolution bill. Okay. This resolution to impeach the President of India by the first House is sent to the other House. For example, if it is initiated in the Lok Sabha, it is sent to the Rajya Sabha. Because the House which has initiated the charge will never have option to investigate the charges. So it is only the second House that can investigate the charges that have been leveled against the President of India. The President of India has the right to defend himself in the investigation process in the second House. If the second House also finds that the charges are not serious, after hearing to the President of India, then the charges could be dropped. He cannot be impeached. See, the first house has passed the charges against the president. But if the second house, which is the investigating house, finds that the charges leveled against the President of India are not valid or are not significant, or it is not against protecting, preserving, and defending the Constitution, then the charges are dropped. But if the second house finds that the charges against the President of India are serious and hold good, then the impeachment resolution is put to vote and can be passed by 2/3 majority of the total strength of the house. 2/3 majority of the total strength. So it has to be passed by 2/3 majority of the total strength of both the houses. Then the president is declared impeached. However, the president can go to the Supreme Court challenging the removal from the office on the ground that the procedure followed for the impeachment of the president is incorrect. If at all the procedure followed for his impeachment is incorrect, then he can go to the Supreme Court. Also note that in the United States of America, the Chief Justice of the Federal Supreme Court and the Speaker of the Congress play a role in the impeachment of the President of India, but they have no role to play in the impeachment of the President of India. In USA, they have a role, the Chief Justice of the Federal Supreme Court and the Speaker of the Congress. But in India, for the impeachment of the President, the Speaker of Indian Parliament or the Chairman of the Indian Parliament or the Chief Justice of the Supreme Court of India do not have a role in the impeachment of the president. Impeachment is a quasi-judicial procedure. It is a quasi-judicial procedure. That is partly because Parliament is using, it is partly judicial procedure because Parliament is using quasi-judicial powers to impeach the President of India. Okay, so that is why it is a quasi-judicial provision. Now let us discuss Article 62 of the Constitution. Article 62 of the Constitution lays down the duration of time within which the election to the president is to be conducted. If there is a vacancy to the presidential office because of the term of the president coming to an end, the election should be held before the term of the president comes to an end. Okay. If the vacancy is due to the death, resignation, and impeachment, then the election should be held within 6 months from the date of vacancy. Okay. So here it is categorically mentioned that within 6 months from the date of vacancy, the election should be held. For the election of vice president, the difference, I'm just trying to help you understand the difference. For the election of vice president, if at all, the vice presidential office is falling vacant due to death, resignation, or removal, then the election to the office of vice president has to be held as soon as possible. So there is no specified date mentioned, but for the election of the president in case of vacancy, it should be held within 6 months. If a new president of India has entered the office after the office of president of India has fallen vacant due to death, impeachment, and resignation, then such new president will enjoy a full term of 5 years from the day he enters the office. Okay. So having understood the powers of the President of India, okay, the various provisions related to the same, let us try to understand the differences between parliamentary type of government and the presidential type of government in our lecture. Okay. Thank you.